An employment contract is a signed document between an employee and an employer detailing the rights and obligations of both parties. In the Netherlands, employment contracts vary in terms of employee benefits, depending on whether it is a startup company, an international organization, or a local company. In this video, we go over the types of employment contracts in the Netherlands and the things you need to know before you sign that your next work offer. Let's get started. Here are the 7 points we will be looking at in this video. Number 1 is the types of employment contract, then the contents of employment contract, the collective labor agreements, probation period, termination of employment or dismissal, impact of employment contract on your work visa or resident permit, and lastly, the non-competition clause. Contract types in the Netherlands. There are 2 broad categories of contract types in the Netherlands: a temporary contract and a permanent contract. A temporary contract is also known as a fixed-term contract. This is a kind of contract that has a start date and an end date. This date is clearly stated on the contract. A temporary contract can be for up to 6 months or more than a year, but not maximum than 3 years. The conditions guiding temporary contract in the Netherlands is that it can only be renewed for a maximum of 3 times. The 4th time, it automatically becomes a permanent contract. And a temporary contract cannot last for more than 3 years. In other words, you cannot work as a temporary contract holder for more than 3 years for the same employer. However, these conditions do not hold if there are up to 6 months gap between any of the contracts. So if there is 6-month gap from the end of the last contract and the date of starting a new contract within the same company, then the conditions of 3 years and the 3 times does not apply. During your employment under temporary contract, you are entitled to the same terms and conditions of employment and employee benefits as the holders of permanent contract. You are not in any way discriminated against on the basis of your contract. A permanent contract, on the other hand, is a contract with no fixed end date. With a permanent contract, you can work for the same employer for as long as you wish. You can work until your retirement date or until you choose to resign by yourself. An employer can only terminate a permanent contract under very severe conditions, which I will be discussing further in this video. Other than that, a permanent contract is a well-secured form of employment in the Netherlands, and it is protected by law. Next, we look at the contents of an employment contract. These are some of the items that you expect to see on your employment contract. Number 1, the name of the company and its address, the name of the employee and the address of the employee, the address where work will be carried out, the start date and the end date wherever applicable, probation period when applicable, overtime arrangement, salary specifications, relocation costs, leave days and compensation, notice period in case of termination, pension and social security contribution. These are some of the items that expect to see on your employment contract. Some organizations fall under a labor union umbrella and they are guided by collective labor agreements. If your company falls under a collective labor agreement, you would want to know and you would want to read the contents of the collective labor agreements to know the terms and conditions that have been negotiated on behalf of employees by the labor union, because these conditions will be applicable to you as a new employee as well as applicable to your employer. In a lot of other organizations, the detailed conditions of employment is outlined in the employee handbook. A copy of the employee handbook should ideally be given to you when you are offered a job. It is your responsibility to read the employee handbook properly And if in doubt at any time, please seek legal advice before accepting that offer and signing the contract. Next, we look at the probation period. Depending on your kind of contract, the probation period may vary. And probation period in the Netherlands is regulated by law. If your employment is less than 6 months, there is no probation applicable. You will work for the period of the contract and then that's it. If your employment is for 6 months and up to 2 years, then the law requires that you have a maximum of 1 month probation period. And where your employment is for more than 2 years, or in the case of a permanent contract, there is a maximum of 2 months probation period. The probation period should be stated on your contract of employment. And during the probation period, either party can terminate the contract without giving any reasons. Now we look at termination of contracts in the Netherlands. For a temporary contract, the contract terminates at the end of the date stated on the contract. So if you have a contract for 1 year and the end date of that contract says 30th of June 2023, then on that date your contract ends. However, the law demands that the company must inform you in writing at least 1 month before the end of that contract to notify you whether or not they will renew your contract. It is a requirement by law that you are notified in writing whether or not this company will renew your contract upon expiration. However, for a contract that is less than 6 months, notice is not required. For an employee to terminate his contract before the expiration of the contract term, the conditions must have been spelled out in the employment contract, and the employee is obliged to abide by these conditions. Usually, you are required to give a maximum of 1 month notice in writing. Termination under a permanent contract follows a rather very strict and rigid rules that has been set by the government. An employer cannot terminate the contract of an employee who has a permanent contract without going through approval process from the employee insurance agency or through the court. And the employer must document reasons for seeking for this approval. And there are various reasons. It could be gross misconduct, it could be business economic reasons, it could be a case of prolonged illness and things of that nature. The court have to give approval before an employer can issue a notice of termination. However, a permanent contract can also be terminated under mutual agreement between the employee and the employer. In that case, the terms of disengagement have to be agreed in writing, and the employee who have accepted or given his consent to terminate the employment has 14 days to think through his decision. During these 14 days, the employee has the right to retract his decision and say, I don't want to resign again, or I don't want to stop my job again, I want to continue working. And during this cooling off period, the employee has no reason to be afraid of any negative consequence. Again, this is provided for in the law. If you've watched this video up to this point, it's probably because you find the content useful. If that is the case, please consider subscribing and give us a thumbs up. And don't forget to share it with a loved one or a friend. They might find it useful as well. Thank you. Next, we look at the impact of your employment contract and your visa and resident permit. If your employment contract is terminated, ended, or not renewed, this might have consequence on your visa or resident permit. If your employer is your visa sponsor, you would have to look for another sponsor as quickly as possible to be able to continue to stay legally in the Netherlands. The immigration service allows you 3 months to do this. You have 3 months to look for another job, get another visa sponsor to be able to continue to stay legally in the Netherlands. To prevent being stranded at the end of your temporary contract, I highly advise to keep an open communication with your employer. Start right from the time of interview. During the interview process, find out if this job is just for a fixed time period, if there are opportunities for extension, is it tied to a specific project, are there rooms for growth, are there rooms for extending the contract. You want to find out before you sign your contract. Also, find out what they expect in terms of job performance. What do you need to do to be able to be adjudged a good performer on the job? Because when you perform well and you are seen as a good employee, then you have a greater chance of being retained on the job or being given opportunity in other areas of the organization. So you want to have this discussion ahead of time so that you know what is expected of you in performance of the job, and you have to put your best foot forward the first 3 months to 6 months of assuming your job. During your job also, you want to find out how he is assessing your performance, look for areas of improvement, and do your best to satisfy their expectation. Around 6 months into your job, you want to have this communication again to find out how are you doing on your job. What are the prospects of extending your contract after 1 year? Speak with the human resources. Are there possible opportunities in other departments if your current job is only for a project for a specific period of time? You want to begin to explore your opportunities. Depending on the feedback and responses you get from them, if it is assuring enough, you can feel confident that you're going to have a job that will be extended. But if you don't find it assuring enough, it might be advisable to start looking for work already from around 6 months so that you don't wait until the last month and then you are stranded. It's always easier to get another job while gainfully employed than when you are out of job and feeling desperate. Now we look at what to do in case you lose your job. In the event that you lose your job or your contract is not extended, you might be entitled to unemployment benefits. There are certain conditions that you have to meet. These conditions are: number one, the reason for your unemployment is not as a result of willful decision or a fault of your own. And number two, you must have worked for at least 26 weeks out of the past 36 weeks leading up to your unemployment. And unemployment benefits can vary from 3 months to a maximum of 24 months, depending on how long you've been in employment. Usually it is 1 month for every year of employment, but limited to a minimum of 3 months. I will leave a link to the Employee Insurance Agency in the video notes. You can visit the website and read more about unemployment benefits in the Netherlands. Now we look at the non-competition clause. The non-competition clause is a remark that is usually included in your employment contract. It prohibits you from working for a competitor or starting a similar business as your employer immediately after leaving his employment. So you want to read it properly to understand the scope of that restriction. In the Netherlands, usually it is expected not to last more than 12 months, but you want to read it before you go ahead and sign your employment contract. Now you have a better understanding of the things you need to be aware of when it comes to employment contracts in the Netherlands. It's now time for you to go ahead and double down on your job search. And to help you stay on the right track, I have a video of 25 best companies to work for in the Netherlands. These are companies that are hiring foreign professionals like you. Click the link on the screen now and watch that video, and I will see you there.